So, hello everyone. This is the Law Learning Capsule, and on the matter for today, we are going to talk about the introduction to the major legal systems in the world, an audio recording of the introduction to the major legal systems in the world with regards to the Ghana legal systems. So, let me give you a general introduction. So, the major legal systems in the world, they are basically the legal systems practiced by each country, and they all differ from country to country. So the general overview here is that with Ghana, most of our legal system has been an assimilation of different legal systems. So it's basically imported versions of the legal systems and its continuous adaptation to change and to meet the social, economic, and political reality of every country. So legal system was defined by a jurist or an American jurist known as Roscoe Pound. And Roscoe Pound defined this legal system as a continuous borrowing of legal materials from other legal systems and assimilating it into our laws. So Ghana, for instance, our type of legal system is a borrowed legal system. And if I say a borrowed legal system, it means that our original way of practicing in Ghana is not what it is now. What it is now is what has been borrowed from the English people, and the English people practice the common law system. So assimilating that in Ghana is when or now that we have the Ghana legals, it's now that we have the common law legal system practiced in Ghana. So I'll move on to give an example. When it comes to countries like Nigeria and Ghana and Gambia, it's easier for a lawyer to practice in these jurisdictions or in these countries. But when it comes to countries like Ivory Coast, South Africa, and other countries, France, it's difficult for a Ghanaian lawyer to operate there because their system of governance or their legal system is different from our legal systems here in Ghana. So please know that there's a distinction between the system of governance and then the legal system of each country. So that is an example worth noting, that lawyers in Ghana find it difficult to operate in a jurisdiction like France because their legal system is way different from ours. So let's move on. There have been several criteria that have been brought up by different jurists to classify the legal systems on the basis that these legal systems, first of all, were not put into any proper or categorically placed in any groups for easy identification. So for that matter, the criteria for classifying these legal systems was introduced by several jurists. And the first view took the view that when we want to classify a legal system, we should look at the substance of the legal system. And when we talk about substance, we are talking about the originality of the legal system. We are talking about the common elements of the legal system, the race and the geography of the legal system. And another view sprang up and said that no, let's look at the legal systems from its political, economic, philosophical, and let's look at it from the political, philosophical, economic perspective. So in that light, they wanted to base the legal systems on these theories that, let's look at how the legal system is going to affect the economy of a country. Let's look at how the legal system is going to affect the philosophies of the country. What philosophies do the country hold together? Let's look at how the legal system is going to affect the political system of the country. You get it? So that was what basically was brought up by the second view or the second criteria that was put up. So this second criteria I therefore speak of, was the criteria that brought about the classifications of the legal systems into three, of which these legal systems are the Romano-Germanic legal system, the common law, and the socialist legal system. And these legal systems have been used by different countries. You get it? But majorly in Ghana and in the UK, we practice the common law legal system. So when we get to the third criteria, this third criteria, they are saying that let's look at the legal system, or let's look at the legal or juristic style of the particular country. You understand? So with this particular legal system, authors brought about 5 factors to determine this particular legal system, since you are looking at the style. So these are first the historical developments or historical background of the legal system. So first of all, they look at what is the history of the legal system, what background does it have. You get it? Okay. So from this factor, from these analogies, or from these reasoning, that is what brought out the English common law system and also the civil law system. So the civil law system and the English common law system, they are very different systems of practice in each country. The common law system is based on historically case laws, and the continental civil law system is based on the codification of abstract rules. You get it? So when it comes to the English common law, they are saying that they base their legal systems on the arising of matters or cases that spring up every day in the courtrooms, or matters that are pertinent to or that are amenable to judicial settlement. You get it? So the continental civil law system also based their way of laws with regards to the codification of abstract rules. And when we talk about abstract rules, they are rules that are put together by people. You get it? And the common law comes from the courts, whilst the civil law, as I said earlier, comes from abstract rules or from study. So let's move on to this. So basically, with everything that has been said, by looking at the 3 criteria that sprang up at the time, these legal systems came to fruition and have come to stay. The legal systems are the common law legal system, the civil law or Romano-Germanic legal system, the socialist legal system, the religious legal systems, the African law legal system, the hybrid or mixed legal systems. So these are the laws that have come to exist under our legal systems. And as a matter of fact, the most dominant ones are the common law legal system, the civil law legal system, the religious legal systems, and these religious legal systems are mostly practiced among Islamic communities, Hindu communities. Yes, so those are examples. The common law legal system also exists, and also the hybrid, the mixture of maybe the two, which is the African and then the religious legal systems. So this is all we have for the introduction to the major legal systems in the world. This is the Law Learning Capsule, and stay tuned for more audios on this page. Thank you.